tend to get a lot of attention. But it is an important directive. Now, traditionally, it has been much more flexible than the public sector regime, with good reason, because it relates to activities that actually are open to competition and also involve private sector entities. So, unlike the public sector where everyone is public body or controlled by a public body, the Utilities Directive also involves a lot of private sector entities. So, what has changed? Has it changed for the better? Do we have simplification or do we have further complication? Well, the short answer is that yes, there are certain simplifications, there are certain clarifications, but the overall sense one gets out of the directive, the new utility directive, is one of further complication. And interestingly enough, it's sort of a counterintuitive way of coming to this, which is by seeking to clarify aspects of the regulation, they have created a body of law which is much more complex. And for the very first time, it's virtually identical to the public sector. Yes, there is still flexibility. It has retained a good part of its existing flexibility, but some of the flexibility in the current directive is now being compromised. And it is interesting, it is useful to remember that back in January 2011, when the European Commission published its green paper that ultimately led to the new directives, there was a question there, which was, do we still need a utilities directive? Can we now trust the markets to drive efficiency, to drive competitive and transparent outcomes? Well, clearly not, because we not only have still a new utilities directive, we have a beefed up utilities directive. Now, I'm going to talk briefly about some of the clarifications, some of the simplifications. In terms of the scope, that actually, sorry, let me just get my slides right. Yes, the scope of the directive, that essentially remains the same. The only thing that changes is that exploration for oil and gas is no longer regulated. It was deemed to be sufficiently competitive, and so it's now outside the new utilities regime. But the other activities remain as they are currently. The Article 30, some of you might be familiar with that. The Utilities Directive, one of the special features is that if a member state or a utility indeed is convinced that the activity the utility activity in question is subject to competition in a market where access to that market is not controlled, is not restricted, then they can apply to the European Commission and seek the exemption, an exemption of that activity from that member state, or indeed part of that member state. We have that in the UK. It was actually the first member state to apply for that type of exemption. So, for example, the generation, production of electricity, supply of electricity is not regulated in the UK other than Northern Ireland by virtue of this article, which remains, has been beefed up, it has been expanded, but is still there. Now, special and exclusive rights, an important term in the directive, and the reason for that is that in order to be subject to the directive, you've got to be either a public body, a contracting authority, a body which is controlled by public body, public undertaking, or indeed a body which might be a private body which is operating a utility activity on the basis of special or exclusive rights granted by the member state. Now, a lot of confusion has been caused by the current references in the directive, the current directive, to that term. And the reason for that is that there is a clear enough definition of that term in the legislative part of the directive, only to be undermined by references to that term in the recitals of the directive. Now, we should mention that the recitals are not the binding part of the directive. They're simply there to clarify, to the extent that there is a need for clarification, what is set out in the legislative part, the articles of the directive. Now, that has led into a lot of grief, really, because some member states have chosen, with the Commission's backing, to incorporate in the legislation the clarificatory, let's call them, references in the recitals when defining the term special or exclusive rights. And that would include countries like France, for example. Some other countries, like the UK, we decided not to do that, and in my view that is a correct approach, because recitals are there for a guide to the extent that there is need for a guide. There wasn't in this case, and therefore we ignored what was set out in the recitals. That means that across the EU currently we have conflicting interpretations of special or exclusive rights, such that, for example, we have clients, airports, that are regulated in the UK as utilities, but are not in France. And that just keeps going. Now, that unhappy state of affairs is now finally being resolved with a new definition, which now brings within the body of the legislation more or less what is currently set out in the recitals to the directive. So, no longer is the question, what is the effect of being granted those directives? Does it limit the ability of others to enjoy those rights? You also have to ask the question, how were you granted those rights? If you were granted those rights, even if they're monopoly rights, even if they're oligopoly rights, if you were granted those rights by means of a transparent process, of a process which was based on objective criteria, then you don't have special exclusive rights. And the immediate effect of this new provision is that a number of utilities in the UK market would no longer be utilities. We won't be classified as utilities. And that would take, for example, in the train operating companies, again, a hot potato in the UK, whether they are or aren't subject to the Utilities Directive. Well, under the current regulations, the utility regulations in the UK, there certainly are. Under the new regulations that will take into account the new definition, there won't be. Well, likely not to be. Right. Moving on very swiftly, let's talk about the complicated side of things. Now, it's important to note that under the utilities regime, a very important distinction is that utilities have access to the negotiated procedure at will. Under the public sector regime, use of the negotiated procedure, indeed the competitive dialogue, is only permissible if you meet certain criteria, certain very stringent conditions. Under the utilities regime, we don't have that problem. We can use the negotiated procedure at will. Despite all that, the legislators, in their wisdom, decided to incorporate, for the first time, the competitive dialogue. Now, the competitive dialogue was a feature of the current public sector regime, which is very cumbersome process, less flexible than the negotiated procedure. And it makes, to me, it just makes no sense why there would be a need to introduce that process, which remains less flexible than the negotiated procedure, into the utility sector. Now, the recitals of the directive seek to explain the reasons why by saying that, well, experience has shown that the competitive dialogue has been of use in cases where contracting authorities are unable to define the means of satisfying their needs, etc., etc. Well, I'm sorry, but that's just rationalization. The reason why public bodies, certainly in this country, moved from negotiated procedure to competitive dialogue was because they had to. There was strong guidance from the Commission, from the government, that forget negotiated procedure, use competitive dialogue. You can only use a negotiated procedure in exceptional circumstances. And therefore that is why there was a switch from one to the other. Not because somehow that procedure had features which were so unique that people went for it. Anyway, be that as it may, I'll just to balance things a little bit, I would just say that actually in that course, in the course of updating the directives, they have introduced certain changes to the competitive dialogue across the directives, both for the public sector and the utilities, which actually make the competitive dialogue much more user-friendly. Now, a feature, if I can call that, of the competitive dialogue is that its provisions are very unclear. And the reason for that is because member states, when they were drafting the public sector directive, the 2004 directives, were pulling towards different directions. We have the Scandinavians and the UK sort of wanting a more liberal approach, and other countries, France, Germany, Italy, sort of pushing for a more kind of restricted view of seeing things. And how do you deal with that? Well, you satisfy everyone by incorporating references which, if read one particular way, point towards a more expansive way of doing things, or read in another, they point towards a different direction, the opposite direction. All that is being changed by very targeted changes in the legislation. So, for example, after the submission of final tenders under the competitive dialogue, what we have is ability to sort of fine-tune, clarify, specify, fine-tune. Thousands of papers have been written about the meaning of these words, and thousands of government guidelines, and it's just been debated ad nauseum. Finally, that is changed. That fine-tuning thing goes, we're going to have optimize. Optimize to me means improving. So for the first time, we'll be able to say, look, when you have final tenders, you can go back in the competitive dialogue to the bidders and actually say, look, let's improve on that. Provided you stay within, remain respectful of the non-discrimination requirements. Again, a similar change after you selected your preferred bidder. At the moment, you can't negotiate. You can only ask for confirmations, clarifications. That changes. We have for the first time references to negotiations. Important change. You can negotiate with your preferred bidder and can finalize. Again, means there's movement. There's not just fine-tuning, there's not just confirmation, there is movement. You can move on the discussion, provided, again, you stay within scope of non-discrimination and all that. Now, I'm not going to, time is running on, but just to say that Innovation Partnership, another new procedure introduced for innovative R&D projects that lead to a product or a service which is new on the market. I don't see the need for that procedure at all. You could do exactly what that process provides under the negotiated procedure. That is introduced under the public sector, is also introduced under the utility sector. Framework agreements, just to say that, again, is currently under the utilities regime is light touch. Hardly, I think there's a paragraph, there's a sentence regulating framework agreements under the current directive. That is expanded into about 4 or 5 paragraphs. Still not as strict regulation of framework agreements as under the public sector, but certainly more than we have now. I won't go into that. That's just a point to say actually that provision here might lead to state aid problems, and we can discuss that if you're interested later. I won't touch that. That'll be discussed by other speakers. Okay, a modification. Many of you would know about the problems that happens once you've completed the contract, you realise, oh my God, we need to change things. What do you do? Well, a lot of us have been there. There is a famous case, the Precetex case, which at the European Court level has defined what is a material amendment, because you cannot do any material changes to the contract once it has been awarded. And the legislators, and this is a theme of the new directives, there is a lot of codification of case law. And as part of that, they have codified the court's decision in the Precetex judgment. Now, at the same time, they went a step further and said, well, actually, okay, let's make things easier for everyone. We're going to define certain safe harbors so that provided you meet the conditions of those safe harbors, you don't have to worry, because we won't consider your amendment as being material. Now, that is well and good and does provide for greater legal certainty. But at what price? Well, to me, the price we have to pay for this greater legal certainty is the loss of flexibility. One size fits all. This is the approach taken by the new directives. we have certain safe harbors. If you're within them, well and good. If you're outside them, you're outside them. Now, part of that process, what we have lost is the flexibility, the ability to see nuances. Back in the year 2002, I think, the European Commission issued a decision in the context, a state aid decision in the context of the London Underground project, where it considered a number of factors in the context of determining whether amendments made to that contract after the preferred bidder stage were material or not. And it considered issues such as the length of the contract. At the time it was a 30-year contract, the complexity of the contract, the innovative nature of that contract. And those were factors which for the Commission were important in analysing and reaching a conclusion as to whether or not in that context it was justified to make certain amount of changes. All that is swept away, all that is lost. We're stuck, well, maybe stuck is the wrong way of expressing it, but all these nuances are lost and we only have to deal with the safe harbors. And for me that is a key downside of the codification of the law in this context. Now, a final point to make is about the termination of contracts. As I'm sure lots of you would know, is that under the new remedies regime that introduced in 2009, we have, for the first time, the ability to set a contract aside, to declare it ineffective. And the three grounds which allow the contract to be set aside, well, now we're going to have a fourth. Through the back door, we are going to have, sorry, where am I? Are we on the road? Yeah. We're going to have a sort of ineffectiveness light, if you like, because what the new rules would say is that there are certain grounds which would allow, which require the member states to provide for the possibility of terminating contracts. Now, it is relevant to know that in this country, the ineffectiveness provisions were only being tested once, and it was within the context of the utilities regime. This was to do with the award by Eurostar of a contract to Siemens for the provision of trains that Alstom challenged in the High Court. And one of the challenges was on the basis that that Siemens and Eurostar have continued to amend the contract subsequent to the award, such that the contract being concluded would have been materially different from that was had been advertised. And so they went to the court, and one of the things they've asked was to declare that contract ineffective, because one of the ineffectiveness grounds is that you award a contract without a relevant notice, without advertising it. And that was the argument. You have changed the nature of that contract so substantively through material changes that it is a new contract that had not been advertised. Well, the court rejected that claim on the basis that even if they were to have accepted that the changes were indeed material, it was not proven that the scope of the original notice did not encompass within it the amended contract. Well, that problem won't occur anymore, because it will be simply sufficient to demonstrate that there's been a substantive change that is effectively a substantial modification. To go to the court and seek to prove that, and if you prove that, you can ask the court, presumably for an order, to require the contracting authority to terminate that contract. So we have an increase in the risk area, if you like, of termination of contracts, which I think is a rather interesting issue. Okay, I won't speak anymore. I think that sort of roughly sums up what I wanted to say. The overall sense, just to just finish with this, is that yes, there is a certain amount of clarification, but the overall sense is one of greater complexity, and one wonders whether a different approach could have led to a much more leaner document, which would have been more respectful of the ability to have more flexibility. Thank you.